Hello, it's Philip Taylor speaking from Richmond Green Chambers in London, and today I'm looking at a book from Hart Publishing, part of the Bloomsbury Publishing plc group. This is on vicarious liability. It's a critique and reform. It's the subtitle of the book. It's written by Professor Anthony Gray. I thought it was a really interesting book to look at because vicarious liability is an important subject to teach, and it's an important subject certainly for practitioners, especially with probably the need for fairly substantial review and reform of this issue of liability in the future. It's part of the Hart Studies in Private Law series, and we've given it a title for our review, Casting a Critical Eye on Vicarious Liability and Considering Alternatives. Let's look at the book first. It's a hardback, it's got a dust cover. It's difficult probably to see that too well, but that's the title. There's the inside cover there, little dust cover, a little bit of information about the book. On the back you've got just a little bit of it, no picture, but just a little bit of information about Gray. Then you've got the index itself, which is page numbering. You can see that. The book runs to 280 odd pages. It's not a very big index at the back, as you can see. We go to the front of the book, and the front has that information, basically the standard blurb about what vicarious liability is and its scope. Then there's the front page itself there. Then you've got the information about Hart and all the detail. Then you've got the table of contents of various parts and the different chapter headings as you go through. Part 1, outline. Part 2, theories. Part 3, miscellaneous issues. 11 chapters, and then a conclusion. In fact, for each of the parts there's a conclusion, which is quite helpful. Then there's an introduction, which is well worth reading, just to get your mind in gear as to what this is actually about. The introduction itself, when I get to it, you can see the author is actually quite self-effacing. He says, "I trust readers will find that this book makes a modest contribution to this debate." Well, he does actually, because it's an interesting debate. Then you see the structure, the outline of the development of liability. Introduction to part 1 there. Then the structure of the book. It's a book which you can just zip through because there's a lot of sort of easy paragraph reading to do. There is the footnoting, as you can see at the bottom, but there isn't paragraph numbering. There are, of course, things like subheads. That's on most recent developments in the area and so on. But what do we say about the book? Because I found, as I say, I saw this book and I thought, right, this is one to definitely have a look at and perhaps do a review, and that's what we've done. Because, quote, "We must always strive to improve the law," excuse me, says Anthony Gray, who's Professor of Law at the University of Southern Queensland in Australia. And in this thoughtful book from him by Hart, Gray presents a carefully argued examination of the rights and wrongs of vicarious liability, mostly the wrongs, if you follow my drift, because that's the basis of his contention. This, however, is a subject that merits careful consideration with a view to affecting positive change in the future. So I think it's fair to say that the publication of this book is therefore timely. Quote, "I believe that the law of vicarious liability and its sister doctrine of non-delegable duties has gone too far," says Gray, pointing out to a whole cornucopia of injustices that emanate from the very word vicarious, which implies, perhaps to oversimplify, that someone is vicariously responsible for the wrongdoing of someone else. Now, that in itself, from a jurisprudential point of view, is an interesting argument to put forward, because there's no real answer one way or the other, unless you legislate and say, no, in future, there won't be any responsibility for anybody else, you're all on your own. Because it doesn't work quite like that for a number of reasons. Most commonly, of course, this situation arises when an employer, as evidenced by existing case law, can be held legally liable for the actions of an employee who, as Gray points out, did not authorise and never would have authorised deliberate criminal wrongdoing. Obviously, tortious liability is another area that's very important here. As well as things that that's the employer, specifically prohibited an employee from doing. And probably we all remember some of the cases, the racing passenger coaches, horses and so forth, where was the work being done in the course of employment. So you can see very clearly what is coming out from that. Because even independent contractors apparently may in effect come under the category of employee. And we've had various matters, certainly in the English and European courts, on the matter of who is an employee, and that matter has not gone away and is still going to be, I think, reconsidered in the 2020s. The author has therefore taken upon himself the task of explaining how and why the concept of vicarious liability has evolved. And to do so, he cites several historical factors, and in the process focuses on 3 jurisdictions with the common law tradition: the UK, the US and Canada. And an enterprise risk theory has been developed in all 3, says Grant, which is said to explain and justify the imposition of strict liability upon an employer for the misdeeds of employees, regardless of the employer's personal fault. And you can see again the thinking that he's adopting in a modern era. This specifically then is what Gray has set out to criticise. His overall aim is a positive one, we think, however, one which is, as indicated by the subtitle, in need of reform. And the author has therefore proposed a model which, while no doubt imperfect as he admits, will at least produce what he considers to be better outcomes than the current state of affairs. Readers are therefore encouraged to cast a critical eye on vicarious liability and to consider alternatives. And that's why I think if you're a student looking at this area of law for your degree or postgraduate studies, this book is for you, because it's certainly an area which is the subject of debate. Let me conclude by saying this. As the ongoing debate on vicarious liability rages on, more or less incessantly, this carefully researched treatise provides a much needed alternative perspective, a critical eye indeed, on this contentious subject. And corporate lawyers, particularly of the comparative variety, we think, will find this book a rather fascinating read. And the date of publication is cited at the 20th of September 2018. We'll just have a quick look at the book again, because as I say, it's a bit not that easy to see it, but you can see the title there. It's a hardback, so there's just the spine and just that name on the spine. There's nothing on the back. Just opening it in the middle, this is, I'm just looking for something, Introduction to Agency Theory of Vicarious Liability. I think this is one of the areas where there is concern. You can see there's a lot of footnoting and a lot of detail there, but this is another area of great concern, because it really is, it's not just a question now of what we can't call them it now, master and servant, but that's what we used to call it. That's what I used to know as them when I first started reading law 50 years ago. However, what we're talking about here is something slightly different, because we're talking about not just employer-employee, but we're talking about a wider group. And the question then is who the employee is in a modern society, because you've got different types of organisation. Big thank you anyway to Professor Grant. I'm very grateful to him. Gray. I do apologise, not Grant, Gray. Very big thank you to him and all the people at Hart for publishing this excellent book. It was well worth reading. Thank you. Bye-bye.